Well, welcome everyone. Welcome to COVID-19 Business Legal Alert, Navigating the New Norm. My name is Gwen Walraven, and my colleague and I, Karen Hart, are partners at the law firm of Bell, Nunnally and Martin in Dallas. Say hi, Karen. Oh, you don't have any audio, Karen. And we're off to the races. Now you can say hi, Karen.
Hi, everyone.
So Karen and I are very, very pleased to be partnering with the Richardson Chamber of Commerce today to bring you what we hope will be a very, very informative webinar regarding what we're calling Navigating the New Norm. These are certainly interesting and new times that I think we're all just trying to get used to. I have lived in Richardson for over 10 years. So the businesses, both small and large in this community, as well as the citizens, are very near and dear to my heart. So again, we are very, very happy to be a part of this process today. As you can already tell from our audio blip, this is our maiden voyage in terms of using Zoom with the webinar feature. We are trying to work the kinks out. I think we've got most of it down, but if at any time you can't hear or you're having problems seeing, use the chat function, raise your hand. There's a Q&A feature as well. Since we are in a slightly different situation in that we cannot have people sitting next to us running our technology for us, or at least assisting in reading the Q&A because of the stay-at-home orders, we're going to be trying to do a little multitasking as part of this process. We are going to try to save some time at the end to address your questions. If we do not get to questions, I urge you to write them down. We will be happy to answer questions via email and things later, or perhaps set up another time to provide more additional information. With that being said, we have in the last 2 weeks gotten a ton of questions on a daily basis from existing clients, as though and friends, family, everyone kind of asking, what is the world going to look like with COVID-19? There are issues that are facing companies, both small and large. And we did our best for purposes of this webinar to come up with a list of what we're going to call hot topics. 4 categories that we think will be of interest to the folks participating today. First, force majeure clauses, debt management, both up and down, federal COVID-19 legislation. I'm going to throw in a caveat here. This is a fluid situation with respect to the legislation. We're going to be offering a very high level kind of introductory analysis of that, but we'll do the best we can to address questions to the extent you have them. And lastly, the shelter in place and stay at home orders that have pretty much covered most of the surrounding counties, surrounding Dallas County and Richardson in particular. With that being said, I'm going to turn things over to Karen and let her begin with force majeure.
Great, thanks, Gwen. Great to be here. And let's see if I have control, Gwen.
I think you do. Click on the screen.
I'm clicking.
And then there you go.
Okay. Oh, okay, there we go. Well, I'm sure many of you have heard the words force majeure over the last couple of weeks. And I know there have been a ton of questions that I've received from clients and business partners that are wondering what this might hold for their contractual obligations, this whole situation, for their companies and for people that they're doing business with. We'll talk more about kind of the business circle of life later in the presentation, but I think we're all trying to manage and figure things out. So many of you may be faced with dusting off your contracts for the first time and digging in the back boilerplate to actually get down to maybe even read your force majeure clauses for the very first time. And it's important to do that at this juncture. The question of whether this COVID-19 outbreak and even the government closures, mandated closures, are going to be a force majeure are going to be driven by the terms of your contract. So it is essential for business owners to gather up all of their pertinent agreements, with their vendors, with your customers, and start putting it together. Go get your files electronically, physically. You need to go dig it all out and sit down and actually pull out the terms of your contract, because no one can tell you whether this event or events, I think is really the correct way to perhaps characterize this whole situation, is going to be a force majeure where there's an excuse for performance or compliance with contractual provisions without reading the contract. You have to go back to the terms of what's in your agreements. And there's some common law, what we call common law defenses for performance that I'll cover, but they're much more narrowly construed. So there may be some arguments if your contract doesn't address force majeure, if there's just nothing that is addressed on this. But it's common to have them, like I said, in the very back of your contract, in what a lot of people just view as boilerplate, where maybe not a lot of emphasis was placed on it. So you've got to go back there and actually find the paragraph called force majeure. Sometimes it's called impossibility. Sometimes there's a paragraph called liability. So you just have to look at your particular agreement, because there's all kinds of different ways of wording this. There's just simply no standard force majeure clause. So we're going to talk about some samples and some typical language that you may have, but you may not have it, because there's just simply no standard clause. Now there's some things that are traditionally found, and we'll talk about that just by way of example. But a force majeure clause it's a negotiated clause, just like any other contractual provision. And they vary based not only just by the contract, but also by industry. So for example, I was just looking around for some sample force majeure clauses and was coming across some sample agreements for example, contracts in the computer web software industry, where you're going to have force majeure clauses that even reference computer viruses. So it can be that specific to the types of events that the contracting parties are trying to allocate risk on. And that's what these clauses are for. It's a risk allocation for if and when something crazy happens, what's going to happen on being able to say, well, I'm excused from performing my obligations, and therefore I'm not in breach of this agreement, because that's what we're talking about here. So again, can't stress it more. You have to actually look at the actual terms of your contractual agreements. And again, the contract controls, and hopefully some thought was put into it, but maybe not. I mean, and it also depends on the leverage in any given contractual relationship, right? Maybe you had all the leverage and you were able to utilize a form that's beneficial to your company, but perhaps if you were not in the leverage position and you had to accept a form from your business partner on their terms, the terms may not be as favorable for you. So that's why it's important to at least get your arms around what you're dealing with, so you can start making plans and strategizing on how you're going to deal with it for your company, and then also with respect to your other business partners that we're all obviously trying to row together as much as possible here on managing the situation. So I pulled this. It's a sample clause. This may not be in your agreement. It's just an example. And this one is probably more even-handed than most that you might even see. I mean, it just kind of depends on what your lawyers were using as far as their draft agreements, and again, it'll depend, like I was saying, on the leverage in any given contractual negotiation, and then of course how much emphasis was put on this type of clause. But this one, you can see here, it says, should performance of any obligation created under this agreement become illegal or impossible by reason of, and then we've got fire, flood, storm, an act of God, governmental authority, labor disputes, war, or any other cause not enumerated herein, but which is beyond the reasonable control of the parties. Then the performance of any such obligation is suspended during the period of, or to the prevention or hindrance of, provided the affected party provides reasonable notice of the event of force majeure and exercises all reasonable diligence to remove the cause of force majeure. So we have quite a number of things that are operating in this clause that, again, may or may not be in your particular contractual scenario or your agreements. But here you can see that this clause, it's even-handed in the sense that either party can activate it. So buyer, seller, landlord, tenant, whoever's on either side of the contract can go to this clause to say, all right, there's an issue here, and I'm not going to be able to perform because of this event, because it became impossible, or even in the case of the governmental prohibitions, and we'll talk more about this in a second, on operations, and might even be illegal. And illegality is a whole other presentation where we could go into this quite in detail on whether the contract would be voided, et cetera, et cetera. But this type of event where the government has made it, in theory, illegal to operate, that would be an example of where this type of clause would come into play. And I think that it's important to look to see, does your contract have any reference to government action or changes in the law, that type of thing. To see if you're going to fall under the list of events that are found in your force majeure clause. And then you can see here, and we'll talk a little bit more about this, we have a catch-all, so there's some specific events that are listed, and then there's, we have this any other cause, the catch-all clause. So it's really important to see if your contract has a catch-all clause in the force majeure provisions. Some do, some don't. And then there's different wordings of the catch-all that we'll talk about. And then you'll also see where I've highlighted the notice provision in this particular sample clause. So there's different notice provisions that can come into play as well. So again, you got to pull it out, you got to read it, and you got to work to understand what the rights and remedies and obligations are for the respective parties under the agreement. And like I was saying, under the leverage situation, you may not be able to activate this clause depending on the wording, or your business partner may not. If this was on your form and more to your benefit on whether something's going to happen to your ability to perform. So the wording is absolutely central here. And the courts in Texas and many other jurisdictions have found that when you have a force majeure clause, the rights and remedies are going to be governed by what the clause actually says. So let's talk about this. So you can see the list of events. These are just samples, okay? So the list I have on the left over here, starting with flood, earthquake, fire, storm, similar to what we saw in the sample clause. These are some of the more traditional events of force majeure that you might find in your contracts. They, again, may not be there. So clearly we've had natural disasters forever, and these things have, these types of events have originated in historical agreements over the decades and even the centuries, going all the way back to England and English law, common law. But here we can see how these traditional terms, quote unquote, have evolved to even include acts of terrorism. So before 9/11 happened, that was not necessarily a very common force majeure event to be listed, but certainly after that, we can see how world events have changed what people are thinking about and the risks that people are thinking about allocating. So you'll often find that in certain contractual agreements, much more common since that time. So in the middle, you can see I have question marks next to epidemic, pandemic, or virus. Probably less likely that your contract has it, but if you do, that's going to be a plus if you're trying to activate the force majeure to provide an excuse for performance. And certainly pandemic, if that's specifically referenced, okay, virus or sickness, illness. So those would be less likely to have in your kind of stock standard force majeure provisions. But again, you got to read it to see if it's there. I'd say it's probably more common to see those in healthcare oriented contracts because that's something that's going to be on, healthcare related businesses' minds on what could affect their business. So again, it's just planning for what the likely risks are. And then, of course, we looked at the sample clause that did have the act of God clause and also the catch-all clause. So I think those are the two wild cards, certainly for whether, your contract is going to, or this event is going to fall under a force majeure. I think act of God, the catch-all, and then force majeure descriptions describing government authority or changes in the law where again, these closure orders have come into place all across the country, statewide, locally, and at the county level, and even at the city level. So it's going to be a local assessment, and we'll talk more about some of those orders later. So I think that's really where this is going to fall. And certainly looking at how an act of God is defined, it's typically defined as a force or act of nature that's unforeseeable, that could not be prevented by reasonable foresight or care. And so, of course, this pandemic is going to be litigated. And you have to appreciate that, okay, so your contract has this, and you or your customers or your business partners, we're all going to be trying to sort this out on declaring, and I think probably all of us have some argument on some contractual obligation that we're going to want to have at least put on hold here for a while we figure this out. So you're not paying, you're not performing, you're not doing what you're supposed to do, customers aren't, how to manage that. But all of us are going to be trying to make these arguments and figure things out. So I think that it's going to be where there's probably going to be litigation as this settles down and the fallout starts getting going on, okay, now we're getting serious about, the big obligations that are worth fighting over. This is just going to be a litigated point. The courts have basically said that it's got to be an act of God. And it's kind of one of those things, like the Supreme Court said, pornography, you kind of know it when you see it. Much of the descriptions that you find for act of God is kind of driven by the event that the courts are faced with. So it's kind of going back to, again, these storm events, hurricane, tornado. So the courts are using words that seem to apply for those types of events. An unusual, extraordinary, sudden, and unexpected manifestation of the forces of nature which man cannot resist, or that cannot be prevented by human care, skill, or foresight. So kind of interesting when you think about it from the standpoint of a virus spreading on human interaction, right? On how that's going to play for the arguments. But at the very least, the three main prongs are that it's abnormal or unusual, probably have that here, and that it's a force strictly of nature. Certainly there's an argument for that's how it got started, with no human assistance or influence. I think maybe there's some argument on the flip side, but I don't think you have to do anything for this virus to spread, right? I mean, it's just a matter of just being in contact with surfaces or droplets, etc. And then it's of such severity that human prudence or precaution could not have avoided the damage thereby caused. So I think there's probably some strong arguments for that as well for business owners. I think there's been a lot of criticism of the government lately on whether more could have been done from that standpoint. But for business owners and contracting parties, I think at the start of this, certainly there's going to be some arguments that there's really nothing that could have been done. I mean, what more could we have done? Because we just didn't know that this was coming. So I think there's going to be strong arguments here that this would fall under an act of God. But again, it's going to be litigated. So Gwen and I, the lawyers will get a hold of this. We're going to make our arguments for or against it. And at the end of the day, it's not just going to be a snap determination on these issues. It's going to be a question probably that would go to the jury on whether something like this would be an act of God. And then also, you have to think about the causal connection, right, to the obligation as well on, okay, this happened, and did this actually prevent you from performing your obligation? There's a case out of Louisiana in the Fifth Circuit that I was looking at. There was a storm that prevented this supplier of nutria pelts, kind of weird. This went to litigation, but the supplier of the nutria pelts attempted to argue that it couldn't meet its contractual obligation to supply those pelts because of this storm. But ultimately, after it was litigated and the facts were presented to the fact finder, the court, who was the fact finder in that case, it wasn't a jury trial, determined that, well, actually the real cause was not because of the storm. It was another cause related to the failure of the pelt supplier to do what it was supposed to do on other basis under the contractual relationship. And so the court basically found that the storm had nothing to do with it. So I think we're going to have a lot of those issues that will come up. So it won't be necessarily a black and white argument where that you're just going to be excused automatically, right, of your obligations. So the catch-all clause, like I was saying, I think this will be key. Maybe your contract doesn't say act of God, but maybe it's got a list that includes, fire, flood, that sort of thing. Maybe it doesn't reference government action or changes in the law as a force majeure. So, but maybe you've got this catch-all. And I think just like with force majeure generally, you can have a broad force majeure provision or a narrow one. And I think the broader the force majeure clauses are, the more likely you're going to be able to make arguments that this event, these government closures, et cetera, are going to help the argument that you didn't have to perform, right? That a force majeure has occurred. So that's where the catch-all comes in, where it's a broad catch-all, more chance to argue that this is going to be a force majeure, this event. But you got to read the fine print on what does your catch-all actually say. Is it broad, like the sample that we were looking at, other events that are not enumerated herein, that are beyond the reasonable control of the parties? Or does it say other similar events? Okay, so you've got your specific list in your contract, and then does it say any like events or any other similar events? Because if it's using that kind of language, it's more likely that the courts may look to the list to say, well, is this event like fire, flood, storm, okay, versus a more broad interpretation where you're not going to be limited by the specific list. And that's a concept of that I've got there on the last point on this slide. Is justum generis. It's a Latin concept and a legal concept that basically says that the general is going to be limited by the more specific. And so it really depends on how your catch-all phrase is worded, on whether you're going to have broad arguments or you're going to be narrowed in your arguments on what's going to apply here. So of course, we were talking about the standard for non-performance. The obligation in the contract has to become impossible or impracticable or illegal. And these standards in much of the case law in Texas and in many other jurisdictions, and by the way, I mean, if you have contracts that are in with parties in different states, maybe you have projects in different states, you got to look at your choice of law to see what choice of law is going to apply. Your contract may provide that. And then if there's not provided in the contract, there's an analysis you have to go through for choice of law. But the biggest point here is that just because you become upside down on the contract, like you entered this contract to make money and to be profitable in your business endeavors. But now, because of this new circumstance, things are going to get really hard, and it's going to be really hard for you to pay the costs associated with performing. And so therefore you're upside down, and it's a financial and economic hardship on you to perform. That's probably not going to be enough to cut it on impossibility or even under impracticability, which are interchangeable under the concepts of the law. Although I'll talk about this in a second. Under the UCC, there's a concept called commercial impracticability, but it's going to be more than financial hardship that has to be shown. It has to be shown that it was impossible for you to perform. So keep that in mind, because I know there's going to be a lot of financial hardship all around on performing and moving through. So that may not be enough, and it probably isn't enough. Now, we talked about the notice requirements. Again, what does it require? Maybe it doesn't have a notice requirement, but if it says reasonable notice, well, what's reasonable notice? That's always an issue. Does it say immediate or prompt notice? And so this is, again, where the contract's requiring the party that's invoking the force majeure to say, hey, seller, I'm not going to buy because of this force majeure. I'm not going to fulfill my contractual obligations on buying the widgets I agreed to buy because this force majeure has occurred. And so it depends if it says if it's immediate notice, or maybe even more specifically within 5-10 days. I mean, there's a variety of periods that could apply. So then we get into this question of, when did the force majeure begin? Who declared a pandemic? When President Trump declared a national emergency, when Governor Abbott declared a state disaster and entered his restrictive order that we're going to talk about later, or when the Dallas County issued its shelter in place or safer at home orders requiring everyone to cease physical operations except for essential businesses. So there's probably going to be debate there on when a force majeure actually started under your particular contractual circumstances. So, okay, so outside of your contract, okay, what if your contract doesn't have force majeure in it, or any terms that address this? So there are arguments in the common law where you can find common law references. So again, the parties didn't contract for it to allocate the risk, but these are defenses to performance. So you didn't perform because of this whole situation, and then if someone comes to try to force performance through the legal process, this is a defense that can be asserted to say, I am legally excused from performing. But mind you, these are very narrowly construed defenses. And so it's kind of a rough road and a very uphill battle to justify the failure to perform. And impossibility and practicability, they're used interchangeably under Texas law, but is literally where the thing necessary for performance has been destroyed or deteriorated, or where the action is prevented by government regulation. And so maybe that's the one that's the ticket on this, on being able to establish this defense. But we'll talk about later how we have a true patchwork of these orders that are limiting operations, right? Are you an essential business? Should you continue to operate? Or is it unsafe for your employees or your customers for you to continue to operate? And what if you operate and you're continuing to have in-person operations, and someone comes in and catches the virus at your establishment? That's another kind of legal liability, right, that you'd have to be managing here, in addition to managing whether you can and should continue to perform under your contractual obligations. And so this example, where the situation must be such that the thing literally cannot be done. The clearest example I can give you is, for example, you have a performer or a performance group, a band, who's contracted and obligated itself to go play and perform on a certain date at a concert hall. However, the concert hall has burnt down and hasn't been rebuilt by the time the band is supposed to perform. It's impossible for the band to meet its obligation to perform at the concert hall on that date, because the concert hall has literally been burnt down and doesn't exist anymore. So if the concert hall tried to sue the band for failing to breach, that would be or failing to perform and sue them for breach, that's a clear argument that it was impossible for them to perform. And again, I'll just point out once again, even under the common law, it's more than just mere financial hardship that has to be established. And so I put this up here. We won't go into detail because there's a lot of ins and outs under the Uniform Commercial Code. If your contract doesn't have force majeure terms, you do have statutory defenses potentially to performance under the Uniform Commercial Code. And each state has what we call codified or enacted uniform commercial code, which is typically going to apply to the sale of goods. And under this section 2.661, sorry about that, 2.615, I lost my screen, Gwen.
Oh, okay.
Wait a minute. Okay, I can do it here. Okay, so the seller, under this section 2.615, the seller, as long as the seller does not assume the risk of the event, so in other words, there's a certain force majeure clause where risk is allocated, and the non-occurrence of the event was a basic assumption, right? So you're assuming that you're not going to have a fire that's going to burn down the concert hall, right? That's a basic assumption of the contract. Then performance becomes commercially impracticable as a result of the event. So then you're back into some of the same arguments that you find under the common law on impracticability, as well as some of the court's interpretations of what that might be under the contract law. So, okay, let's see. Am I advancing it, Gwen?
Yes, I advanced you to leases.
Okay, thank you. Okay, so I know a lot of you have leases on your mind. You might be tenants, you might be landlords trying to navigate this. The main thing I think you've got to watch out for leases is a lot of times there are carve-outs, and I do a lot of landlord tenant litigation, do a lot of real estate litigation. So what I know about force majeure clauses under many commercial leases is that there are carve-outs for payment. So you might have an obligation as a tenant, for example, to be continuously in operation. Okay, yeah, a lot of leases have this where you just can't be closing up your shop willy-nilly because the landlord wants to have a nice shopping center with shops that are open, etc. So those are common terms to have where there's a continuous operation clause essentially. So the force majeure clause, you know, maybe there's some very strong arguments on, well, hey, I had to shut down my bar and restaurant because I was obligated to under Dallas County orders. So, okay, there may be some strong arguments there, again, depending on the wording of your particular clause. However, many of the leases do have carve-outs for monetary obligations. So there's literally exceptions to say, except for payment of rent. So that's something to at least be aware of on both sides of the equation here for landlords and for tenants. And so it's just something to actually look at and know about before you haul off and activate the force majeure clause as a tenant, of course. And certainly there are also other clauses in leases. There's often catastrophe clauses where there's certain notices that have to be provided. You know, perhaps it meets the catastrophe clauses might be activated by this, but a lot of them are related to physical damage to the premises, you know, where there's a hurricane or a tornado, that type of thing. But nevertheless, worthwhile pulling out and taking a look at it. Because sometimes there is rent abatement that's available contractually in the event of a catastrophe, but there's certain notices that are required to be given by the tenant or by the landlord even. And also you should check to see, number one, we don't have time to go into the insurance implications of this event. That's a whole other presentation that we could do. But certainly you need to be pulling out your policies and checking and working with your brokers to find out what coverage might be available. And then certainly you need to look to compare and contrast with your lease agreements to see what you were contractually required to have, and see what it says about, number one, business interruption insurance. I was just dealing with this issue last year, not related to a pandemic, but it was a flood or a pipe burst type of thing. And so we were working with, I was representing a landlord. And so we were working with the tenant, on these issues, and the lease agreement actually referenced, the tenant's responsibility to have business interruption insurance in the event of such an occurrence. So it's really important to look to see what was required, and hopefully you're meeting those requirements, and then to activate the coverage where you can, and work with your insurance professionals to assist you with that. And of course, your lawyers on understanding your policies. So we've covered notice requirements. Okay, you want to advance, Gwen? Okay, so I thought this was maybe useful to just understand that depending on the wording of the clause, landlords may even be able to take advantage of and consider activating force majeure. For example, if you have to close all the common areas of your shopping center. I mean, there's been a number of malls that have shut down. There's been a lot of national tenants that have closed up their doors and decided not to operate just on a national basis. And frankly, there's been some national tenants that have announced that they're not going to be paying rent as well for the next couple of months. So this is a whole issue that we're going to talk about here in a second on managing all this. But anyway, there could be opportunities for the landlord to activate it, to argue that they don't have to meet co-tenancy requirements or occupancy percentages in light of this whole situation. But again, it's going to go back to what the terms specifically are and what the situation is holding. Okay, you can advance it, Gwen. So in sum, there are risks and benefits that you need to think about with these, with the concept of force majeure generally, as it applies to you and your business. So again, you might have to make some calls on whether you are going to activate it for your business. And declare a force majeure because you may be under notice requirements. Okay, and we're going to talk about this in a second as well, on making sure that you're perfecting your contract rights. Because if you don't provide the notice, if it says within 5 days and you don't provide the notice, there's case law that says that it's fatal, that you're not going to be able to fall back on this as an excuse to your failure to perform. So you've got to make sure that you're checking all the boxes, dotting the I's, crossing the T's, and doing what you need to do to protect your contractual and even statutory rights. But I guess the rub here is if you're wrong or if you're premature, just even declaring it could be a breach, right? And then of course, if you're not performing, that's going to be a breach as well. And then we've already talked about this carve outs for payments or monetary obligations. And I think that that's true for any contract, even beyond the rental agreement world. And then of course, what if you are on the receiving end of a force majeure notice? Then what do you do then? And we've got some slides that will address some strategies on that. You want to advance? There you go. Handing it back over to Gwen.
Excellent. Thank you, Karen. So even if you are actively trying to avoid the news, as some of you might be, and myself included, I think it goes without saying that the economic impact of the pandemic is being currently felt already, and we can assume that it's going to be felt in the foreseeable future. And non-payment of debt from the bottom up has a domino effect. It's circular in nature as well. So whether you're a buyer, a seller, a landlord, a vendor, a lender, and any other manifestation of things in between what you see on the screen, you're likely to be impacted at some point or another. Because even if you're the landlord, you may have a mortgage on the property, so you have an obligation going up, even though your tenant has an obligation to you. So a very simple example that can kind of explain the domino effect of what we're looking at is, say you manufacture paper clips. You have your own plant, you manufacture them on your own, but you owe a mortgage. The bank is part of that mix, but you sell your paper clips on credit to large companies who buy in bulk paper clips and sell them to their customers. All of a sudden the pandemic hits, and for COVID-related reasons, the paperclip purchaser can no longer pay you, but you've extended credit. So then the paperclip purchaser says, well, I can't pay for the paper clips because I have to pay my landlord. And on a one-off, that might be fine, except if you have 5, 10, 15, 25, 30 or more purchasers who are at the same time are not paying, now that puts the manufacturer in the position where they're having problems paying their landlord. We all have accounts payable, we all have accounts receivable, and so the key to all of this on a going forward basis is going to be balancing the customer relationship and your bottom line, keeping cash flow in mind, and the fact that it's probably accurate to say that you worked to foster customer relationships to get the business in the first place. So you don't want to be taking rash action in this particular climate that's going to jeopardize that relationship. But as Karen noted, there are certain things that you simply have to do to be able to preserve your rights on a going forward basis. So the key that you're going to hear in the rest of this presentation and that you've already heard is be proactive and communicate. I've been practicing in the creditors' rights world for 15 years, and the number one problem that happens when people owe money is they put their head in the sand and they think if they ignore the problem, it will go away, and it won't. So reach out, talk to each other. If you are on the creditor side of things, go ahead and reach out to your customers, check on them. How are you doing? I mean, in this particular climate, there's no easier way to start a conversation than reaching out to someone and saying, how are you weathering this storm? Find out if you're a priority on their payment list. I think that people are going to be pretty frank that, look, I've got to keep the lights on, so landlord's going to get first preference, or my lender, or whatever they have to pay before you. But start understanding kind of where you are in that chain so you can assess your own cash flow needs. And on the same token, flip side is reach out to the people that you owe, manage their expectations. It's not necessarily that you're going to reach an agreement off the bat, but at least everybody kind of knows where they're standing. Consult with counsel sooner rather than later, or whoever your advisors are with respect to whether it's an insurance issue, maybe it's a tax issue, then you're talking to your CPAs. But whatever happens, you want to make sure that you're not inadvertently putting yourself either in default under an agreement, waiving an applicable statute of limitations, because maybe you've had AR that's been sitting out there for a long time and now it just got bad, because perhaps they'd been slow paying and you were fine with that, but now they're at a point, whoever owes you is at a point where they're not going to be able to pay. There's really creative things that you can do in terms of workouts and the like that we're going to talk about here in a minute. So let's start with, you're on the creditor side. You're not getting paid, now what do you do? So the first 3 items that you see on this slide, they seem harsh at face value. I concede that point. Demand letters, nobody wants to get them. Some of us like to write them, but that's because we're litigators. But in any event, there's notices that you have to preserve lien rights or rights under other agreements. The stuff that Karen talked about in terms of, do you have a 5-day notice provision? Are you enforcing a force majeure clause? Lien rights in and of itself, we've got colleagues that teach seminars that go on for hours because the Texas law on how to preserve a lien right in the construction industry is incredibly specific and involved, and you really have to follow it to a T. So some of these things you may have to do, whether they're the warm and fuzzy thing to do or not. Including filing a lawsuit. If you're at that point where statute of limitations is going to be an issue, or if you simply think that that's going to be what it takes to get your debt to get more attention than maybe some of the other debts, that may be a strategy that works for you. But I will say in the last 2 weeks alone, I'm already getting requests from customers that have reached agreements with my clients in the past to do payout agreements for alternatives. What can we do to change things up because they're hitting hard times? So that goes in, working with customers. One of the things, back up under notices to preserve lien rights, any of the bankers out there, and even if you're not a banker, you've done some financing and you've got promissory notes in place. Texas law is very strict in terms of acceleration clauses. Usually it's always advisable, depending on if you've really hit the perfect words in your promissory note, but to give a notice of intent to accelerate and then a notice of acceleration. So again, sounds harsh in this climate, but so long as you pair any of these three top items with working with your customers, there's nothing to say that you can't preserve your rights and then reach out and say, let's talk about this, let's reach a deal. Some of the things you have to do under the law, some of them you can certainly work through and compromise. And there's lots of options with respect to compromise. We do payout and workout agreements all the time where there's a principal due that has just gotten too big for someone, and so they need to spread the payment out over time. Sometimes there's an interest component, sometimes there's not. The good news about compromise, and if you've got somebody on the other side who's willing to work with you, is that the sky's the limit, and your contract with your lender and or other contracts are your limit with respect to creativity. So as long as there's not limitations in an agreement that you've signed, you have a lot of freedom here to really make a process or put a process in place that will work for your customer. For instance, if your customer says, look, I know I owe you $50,000, there's no way I can pay that in full now. You know, do an accelerated, or not an accelerated, but a stair-step payment program, where maybe for the next 6 months, payments are at a certain level, and then they slowly ratchet out over time. And if you need to assess again in 6 months, if you've had, you know, good payment going along the way, maybe that's something you're willing to do. Maybe by then the concern's not there anymore and they're paying more than they even have to. So there's some creativity again there. Consider a reduction of interest rates. The 1.5% per month is the max in Texas. That's 18% per year. A lot of credit agreements that I see have that 1.5% in there. That can add up very quickly. So if that is an issue, you can always agree to perhaps reduce that. And lastly, you could, if you were financially set and it wouldn't put you in violation of another covenant in another agreement, simply wait to take payments for a little while and let everyone get back on their feet. At the same time, where you have a climate that is obviously uncertain and somewhat scary, you can get creative with security options to protect yourself going down the road. Say, for instance, you already have a credit agreement in place, but you didn't get a personal guarantee. Now's your chance. If you're going to agree to give the debtor additional time to pay or lower payments or lower interest rates, now's the time to say, look, I want to secure this with a personal guarantee or a promissory note. I've used promissory notes in very creative situations where, you know, they're signed up and maybe no obligation is triggered at all until there's an event of default under a payout agreement. And then you're in a position where you can fall back on the promissory note. Collateral, you know, if your customer has land, has some other asset. I talked to one of our lawyers yesterday who's currently doing this now where someone can't pay and they are taking a security interest in some collateral, just like a bank would. Now, agreed judgments are really only an option if you're already in active litigation. They are very, very common, and they are an effective way to secure, even if you can't guarantee payment, they can secure an option to you if there is a default under the payout agreement. For instance, say someone has agreed to make monthly payments to the tune of $5,000 a month. You have an agreed judgment for, say, $100,000, but you're agreeing to accept $70,000. So as long as they're making $5,000 payments per month, they have to pay up to $70,000. But if there's an event of default, your contract says that without further notice or with notice, depending on what the parties agree to, you can automatically go back to the $100,000 debt, start taking action to collect it, and you don't even have to file a lawsuit at that point because it's an agreed judgment, it's been presented to the court, it's been signed, and you're golden. It's an excellent way to save on legal fees if you foresee that there could be a default in the future and you don't want to go through the litigation process. Again, you've got to have an active lawsuit to do that. Regardless, the big takeaway here, whatever you end up agreeing to, put it in writing. Everybody wants to be the nice guy until people aren't the nice guys, and you end up fighting because you didn't get it put in writing, and that's the devil's in the detail. So, been talking a lot about the creditor side. At the end of the day, we're all debtors in one way or the other, like I said at the beginning, because you likely have either a mortgage or a line of credit with your bank, or you're the purchaser. So question one, is there any option for you under the force majeure clause? And if so, as long as you meet your notice requirements and want to, give it a shot, that's an option. Refinancing or restructuring. We're hearing from a lot of bankers now that they know it's going to be an uptick and they're going to have a lot of this going on. Something we haven't mentioned yet, and I meant to earlier actually, is that Bell not only has actually got a legal resources website right now that our lawyers literally on a daily basis are updating with new articles with kind of practical application stuff. And there's one out there that's talking about refinancing or restructuring that a couple of our banking lawyers wrote. Again, if you're the one that owes, don't overpromise. If you don't think you can pay more than X amount per month, certainly don't agree to it, because that's just going to put you in a situation where you may be looking at a default, and then that's where things really get bad. So keep that line of communication open and see if there's a creative alternative, such as trading a service in exchange for a reduction. There was a situation I handled for a client several years ago when the economy was good, but they had fallen on hard times, but they just so happened to manufacture a very specialized piece of equipment for a very large and lucrative industry. And the industry needed it. They manufactured it, but they couldn't pay certain other obligations. So we structured a deal where effectively they were trading a service and goods in exchange for a reduction of the debt that they owed. So, and lastly, I think I've mentioned this before, I don't want to belabor the point. You can always creatively talk about reduction in interest and other things like that, so long as it doesn't put you in default of another agreement. So at the end of the day, communication is key. If you're owed, be transparent about what you're willing to consider or not. And if you're the one that owes, be transparent about your situation and what you can realistically afford to pay. I'm going to check here on our time, and this is exactly what I thought was going to happen. We are roughly 10 minutes away. I can very quickly try to run through a high level of federal legislation, and then we can open it up for questions, or we can start taking questions now. If anybody wants to jump in on a chat and say what there'd be a preference on, or raise your hand and I can turn on a mic. I think.
And Gwen?
Yes.
We can keep going if people want to stay. And
that's an option too.
Just go part two. If y'all have time, I mean, we're here for you guys. If you wanna stick around for kind of the second half on the legislation and the shelter-in-place orders.
Okay, so can stay on in legislation are the ones I've heard so far. So let's just jump into legislation. Okay, again, this is high level, it's fluid, and we're doing our best to be comprehensive without getting too far in the weeds. So we're calling this kind of phase 1, phase 2, and phase 3. Phase 1 and 2 are implemented. Phase 3, it's looking hopeful. Senate passed last night, set to go before the House, I believe, tomorrow morning. Currently, so Coronavirus Preparedness and Response Supplemental Appropriations Act is in place, as is the Families First Coronavirus Response Act. And I believe the title of the Omnibus Act is Coronavirus Aid, Relief, and Economic Security Act, which is poised to be probably the largest of its kind we've ever seen. So at phase 1 was really an $8.3 billion influx of emergency funding. What I think is most relevant to this audience in particular is going to be the Small Business Association's Economic Injury Disaster Loan, known as the EIDL. What that allows for is small businesses to get low interest rates, loans up to $2 million. It required certain benchmarks that had to happen first, beginning with a declaration from the governor and then a request to the SBA. Which happened on March 20th of 2020. The SBA actually issued the EIDL, issued a declaration for EIDL for all 250 Texas counties. So, already mentioned the max loan's $2 million. Here's where some of the parameters come in. This is available to small businesses, private and nonprofit organizations. There are restrictions on the uses. There's going to be those listed ones and then the everything else kind of thing that you'll have to get into the weeds on. But in general, it's going to be fixed debts, payroll, accounts payable, and other bills. So there's going to be questions that'll have to be addressed as to what other bills are. The current interest rate for small business under an EIDL would be 3.75 with 2.75 for nonprofits. Now, as enacted under phase 1, there are repayment terms of up to 30 years. You cannot take advantage of this option if you have other credit available. And there seems to be, or not seems to be, there is a requirement regarding creditworthiness and collateral. Now, I am still trying to completely immerse myself in phase 3, but I do believe I read something either yesterday or this morning that seems to suggest that if enacted, the requirement under the EIDL for creditworthiness and collateral will be modified in some way. And part of where you're going to see some confusion, and we'll get to this more at phase 2, is that a lot of what the federal government is doing is when they're enacting these various things, they're amending existing laws that interact with each other. And so there's a lot of confusion out there in some sense of how these all work together. And so I think you're going to see EIDL work in conjunction with phase 3, so I don't have to repeat that really long title. So the next phase, phase 2, is one that we're getting a lot of questions about. This is the one that's going to talk about what employers have to pay in leave, what's mandatory, and what employees can take advantage of should they need it. And this is where I just referenced a moment ago, the Families First Coronavirus Response Act, the FFCRA, actually amended 2 existing laws rather than becoming its own new law. So it amended what most of you probably are familiar with, which is the Family and Medical Leave Act, and it also amended the Emergency Family and Medical Leave and Expansion Act. Those 2 acts operate independent of one another. And so the interplay between them has caused some confusion. The good news is that the Department of Labor actually put out a couple of resource guides that we'll have links to here in a minute that are starting to kind of sort through some of these issues, and that happened within like the last 2 days. So starting with application of the EFMLA, it begins April 20th, 2020. It's slated to extend to December 31 of 2020. Applies if there's fewer than 500 employees, but there are exceptions out there. I think the benchmark for some super small companies is under 50, so there may not be, you may not be required to do certain things if you meet these exceptions. Again, that's a little more in the weeds than we're going to go here today, but something to be aware of. Now, here's the big takeaway from the EFMLA. This only applies, the leave portion of this only applies if their inability to work or telework is due to the need to care for a child under 18 if school or daycare is closed. Well, we all know that schools are closed. Daycare, I believe, depending on which county's order is in place, is open on a as-needed essential basis if you have to work because you're an essential business. But it really, this one only comes into play if you've got to care for a kiddo under 18. But note that the reason it's not broader is that the current thinking is that having COVID-19 yourself, the employee, or caring for a family member with COVID-19 is likely already covered under the traditional FMLA. So that's why it seems fairly narrow. So then we go to application of the EPSLA. Same time period as we saw previously, April 2nd to December 31. Same applicability with respect to the size of the company, under 500 employees. Now, here's where it gets interesting, and where the calculation of what is to be paid or can be recovered via leave by an employee is subject to kind of what bucket of eligibility you fall into. The first 3 prongs you'll see are all geared towards when the employee, his or herself, is infected by COVID-19. In other words, not caring for a family member or a child. So you're subject to a quarantine or isolation order. So that's one where you don't have options. Then there's the number 2, you're advised to self-quarantine. We're hearing a lot of that where people are just doing it because they know they were exposed. And then the employee is experiencing symptoms of COVID-19. So those 3 go into one bucket of how you calculate what leave they're entitled to. And there's some percentages, and depending on how many work hours you work, et cetera. I will say that our team of employment lawyers have put together, again, the resource guide, an article that kind of does the math on this and at least gives you a couple of hypotheticals that you can look through and maybe get a sense for how that would work. And additionally, the guidance that we've recently received from the Department of Labor, I'm told helps with the math as well. So the second buckets, which I'm going to kind of break into really three, 4 and 5 are what I alluded to a moment ago, which is when the employee is caring for an individual under quarantine or is being isolated, or the individual or family member is being isolated. So you've got order, and then you've got a child whose school or daycare has closed. Again, we talked about that a minute ago. And then where the employee is experiencing other substantially similar conditions specified by the U.S. Secretary of Health and Human Services. So when Karen was talking earlier about kind of your laundry list of things, and if you see language like similar condition, that's key in the legal world, because that's suggesting that the 1 through 5, whatever might fall under this new umbrella, has got to be similar to 1 through 5. So again, calculation of benefits is going to vary depending on whether the employee falls under 1 through 3 or 4 through 6. Now, sadly, and mostly because it's just also new, we don't have a lot of information now on phase 3. I can tell you that I'm told from the folks at the firm that they're going to have their resource alert on it launching, the hope is, between 2 and 3 o'clock today. In the meantime, I did a little bit of digging, and I can tell you what I noted before with respect to the possible implication on the EIDL loans. Also, I did see some literature suggesting that there was a small business association component to phase 3 as well. So the question begged itself, okay, if you're taking advantage of a small business association loan under phase 2, what does that mean on phase 3? We actually reached out to some banker friends yesterday, and we're told that their understanding as of now is that they're actually encouraged to take, small businesses that is, are actually encouraged to take advantage of both phase 1 loans and phase 2 loans in the event that you qualify. So that's what we've got right now on the existing federal legislation and that which we anticipate to get an answer on tomorrow morning. With that, I'm going to turn it back over to Karen to give us an overview of the executive orders. I did see some hands going up, so I'm going to again, we're willing to stay on and address questions. And if you have to leave for some reason, feel free to put your question in the Q&A, and we can certainly reach out to you via email later to get that answer.
And we're recording this too. So in theory, we'll be able to make a link, and you can access the video on the Bell Nunnally COVID-19 page. You can access that page by going to bellnunnally.com, and there's a button at the top that you can press to access the page with all the links to articles and ideally this video. So stay tuned on that, but hopefully we'll be able to pull that off.
And Karen, before you jump in, just before I forget, we'll also make this PowerPoint available that has these websites. This is what I was referring to earlier with respect to the Department of Labor guidance. And then, as Karen noted, it's also got a link to our firm's alerts. With that, you're up.
Yes. Okay, so I'm sure y'all have heard about all the various orders that have been going into effect at the state level and then also at the local level, as I was alluding to earlier. Texas, Governor Abbott has resisted putting in place true shelter-in-place orders at the statewide level, like we've seen in California and in Illinois, and I believe also in New York. So he's kind of taking a wait-and-see approach. And I know the business lobby has been very busy down in Austin on trying to inform Governor Abbott of the impacts on the Texas economy in light of such an order. So I think there are big questions and big issues on all sides of this monster that we're all facing right now, from a health standpoint, public health, and then obviously the impact on our economy. So we're all struggling trying to figure it out at the various levels of state and county and city government. So we have a slide here that kind of gives the bullets on the governor's order of avoiding groups of 10 or more. And I will say the interesting way that the order is the order is worded in a very interesting way. It's not an actual directive to bars and restaurants, et cetera, to close. It's a directive to the public requiring that people in the state of Texas are to avoid going to restaurant, bars, gyms, et cetera, and no visiting of nursing homes. Now, the one proactive closure order that you'll find in the governor's executive order is that he did in fact close all schools. So we all know that's been in place. And so the governor basically left it to the local authorities at the county and even at the city level to decide if they want to put into place more restrictive measures. So it's literally on a county by county basis on how these orders are playing out all over the state. And so we do obviously have a patchwork that has developed even in the North Texas region. So Gwen, did you give me control?
I advanced it, but I'll give it to you as well.
Okay. So we have shelter in place, stay at home orders in, sorry, I'm trying to get control here. Did I advance it, Gwen?
Yes, you got it.
So we, as many of you heard, we have shelter in place orders for Dallas, Tarrant, Collin, Denton, and even the city of Dallas, cities of Dallas and Richardson have entered their own orders. Most have kind of followed Dallas County's lead, with the exception of Collin County, who's our rogue county, who's very concerned about the impact on the economy for a total shutdown, essentially. So they're the one outlier that has a little bit of a different order that's mirrors more of the governor's stance on things. So here's a snippet, and we've got links, I think, to at least the Dallas County order, and you can find all of the particular county orders if you want to access them to actually look at the terms. You can find them on the county websites. So just go to Tarrant County or Dallas County, et cetera, to find the actual orders if you need to access them. And I think our COVID-19 website also has some links as well. So obviously the idea here is to limit the traffic of people out in public and to make sure people are limiting their interactions with others. So and mind you, you need to check, because if you checked a couple of days ago or last week and thought you had the most recent order, that they're amending and updating on a regular basis. And Dallas's order is through, I believe, April 3rd. And so we'll have to see if these orders are going to be extended in these various counties and cities as well.
And Karen, can I interject here?
Sure.
Dallas County, I believe Judge Jenkins' power to actually have that order expires on April 3rd. That's why he chose that date, but he anticipates, at least his latest press conference that I saw, he anticipates there being an extension of that. Again, it's an ever-changing situation, but that's the reason for that date.
Yes, so it's evolving, and he's issued, Jenkins in the county, they have a frequently asked questions page to help provide some guidance, because some of the verbiage in these orders is, it's about as clear as mud on some aspects of it. City of Richardson, I mean, again, mirroring what Dallas has done here. We don't have to go into all this. And Tarrant County, same thing. It's a little bit different than Dallas. I mean, there's some nuances here that we don't have the time to go into. But certainly, if your businesses are operating in these counties or located in these counties, you need to pull these orders. And I think the most important thing to think about is the emphasis here is, they're not stopping all business activity. They want it to continue, and they're encouraging and mandating, that you can't go in and work together in a facility unless you are an essential business. But it doesn't prohibit businesses from continuing operations remotely if you can telecommute or telework, as it were. So that's the emphasis of these orders.
And Karen, I'll jump in there and say that another thing that's indicative of that is, at least in the Dallas County order, one of the things that's very clear and is permitted is an essential business if you can provide products to teleworkers, which is why like micro marts and your office supply places are like literally running out of office supplies and things like that, because people are equipping to work remotely. Sorry for the interruption.
No, yes, good. Jump in anytime, Gwen. I'll try to watch you. You can wave and let me know when you're going to talk. So Tarrant County, they were the first, I think, to implement their order, and they were the first to have some penalties and some teeth built into their order. Dallas City and Dallas County have, in the most recent iteration of this order that I have on March 24th, they did include some provisions for fines and penalties for failing to comply. It's a misdemeanor punishable by a fine of not to exceed $1,000 and/or confinement in jail for a term not to exceed 180 days. In the Dallas Sheriff's Office, county fire marshal's office, and other peace officers are authorized to enforce it. So that was kind of a new addition. Before there wasn't a penalty provision in the Dallas orders. So so they're catching up and trying to put some teeth on this to make people take it seriously, right? Same thing in Denton. It's largely this essential business function exception that you'll find, and I'm going to go over that in a little bit more detail. Here's Collin. So again, Collin County tried to stick with the slant that the governor took on this, but ultimately, and it's an order to the people to avoid going to bars and restaurants and that type of thing, but allowing for takeout and pickup. But it also says that anyone or all businesses are essential. All businesses are essential to life happening and the economy, and the financial health and well-being of the economy, and so therefore they are essential to the financial health and well-being of all Collin County citizens. Persons who are employed need to stay employed. Persons who lack employment need to gain employment. Businesses that are able to remain open need to remain open. So that's kind of the tack that they've taken. And they've kind of steered away from this essential business exception. So here's some resources, again, that you can access, and we'll make this available. But I think a lot of you that are business owners may be wondering, if you are an essential business, right? So let me just go over quickly the carve-outs in the Dallas County order. They're largely similar in the other counties with the exception of Collin County. There are some nuanced differences, so you got to read the orders specifically. But in Dallas County, essential businesses include essential healthcare operations, which includes hospitals, clinics, dentists, chiropractors, physical therapy, optometry offices, pharmacies, pharmaceutical and biotechnical companies, other healthcare facilities, mental health providers, substance abuse providers, blood banks, laboratories, and ancillary services. And home-based and residential-based healthcare for seniors and adults are also considered healthcare operations. Healthcare operations, and importantly, we were very concerned about this, also include vet care and all health and welfare services provided to pets. So your pets can be seen by your vets if they're in Dallas County. Now, healthcare operations do not include, and there's specific prohibitions on gyms. Gyms were ordered to close in Dallas County, but it doesn't include personal training, gymnastic studios, etc. And healthcare operations, importantly, for doctors and surgeons and other providers of healthcare services do not include elective medical, surgical, or dental procedures. And there's a definition where you're supposed to get together with your medical provider to determine whether or not your particular procedure is elective or not, based on your doctor's determination. There's essential government functions, and then there's also, and I think this is the critical one for many who might be in the construction industry, critical infrastructure is considered essential. And so that includes residential, commercial, and school construction. So the construction industry is allowed to continue to operate here. It also includes solid waste collection, removal, internet and telecommunications systems, as I think Gwen was maybe alluding to earlier. Includes financial institutions, except for non-depository lenders, which Dallas says, such as payday lenders. It includes payroll, accounting, and insurance companies, and other essential manufacturing operations. So I know a number of business operations have been struggling with whether they fall under this, are they an essential manufacturing operation, et cetera. So, you know, worthwhile to get a hold of your counsel if you're really considering trying to stay open, and like at least go over the options and the pros and cons and where you might fall under these definitions. And of course, we have all heard about the essential retail, which includes grocery stores, warehouse stores, big box stores, bodegas, and importantly, liquor stores, gas stations, convenience stores, farmers markets that sell food products and household staples, etc. Laundromats, dry cleaners, and laundry service providers are also included in this essential services definition. And then, of course, everyone wants to know whether their pool guy can come, whether their you know, their maid can come. There's a paragraph in the Dallas County order that governs that. Essential services necessary to maintain essential operations of residences or other essential businesses. So if you're providing services to the other essential businesses, you may be covered. This includes trash and recycling, landscaping services, processing and disposal, mail shipping and delivery services, building cleaning, maintenance and security, warehouse distribution and fulfillment, which I think that's an interesting one for warehouse distribution and fulfillment, storage for essential businesses, moving services for residential, funeral homes, crematoriums, and cemeteries. Plumbers are also part of this. Etc. So news media is also one of the essential services as well. So y'all need to make sure that you're taking a look at the orders, going over the language, and assessing whether, you know, you are an essential business if you're thinking about keeping your physical locations open. But most importantly, you have the right to continue to operate remotely if you can do that.
Okay, with that, I think we can open it up for questions. And I'm guessing the best way to do this, because everyone is technically muted, so if you have a question, if you'll raise your hand, I can enable the mic, and then you can ask your question, I think.
And then they can type in questions too, right?
Absolutely, both of those will work. And if we don't have any questions, then that's fine too. Okay, we may not. We'll give it a couple of seconds in case somebody wants to type a question.
And listen, I think our contact information is somewhere on the PowerPoint.
It is.
And we'll figure out how to distribute that to y'all. We'll probably just create a link on our firm website where you can access it. We'll work with the chamber on getting it out to you. But feel free to reach out to either me or Gwen to ask any questions that you might have. We're here to try to help support y'all. Oh, I think we have a question, Gwen.
Oh, where are you seeing that?
Oh, no, I don't think so.
Okay, all right. All right, well, with that said, thank you so much to the Richardson Chamber of Commerce. This was our pleasure and thoroughly enjoyed it, and hope it was helpful and beneficial to all. And for now, stay safe, and I hope you're all enjoying your mobile remote offices. So thanks a lot. Take care.
Stay safe, everyone. Be well. Bye-bye.